This week, the Supreme Court heard a case on whether or not the government can force pro-life pregnancy care centers to advertise for abortion. The case, National Institute of Family and Life Advocates, or NIFLA, versus Becerra, centers around a California law requiring pro-life pregnancy centers provide information about free or low-cost abortions. Both conservative and liberal justices raised questions about the law during the hearing. Even Justices Elena Kagan and Sonia Sotomayor said they were troubled by aspects of it. Cardinal Timothy Dolan, chair of the U.S. Bishops' Pro-Life Committee, issued a statement saying, in part, rather than applauding and encouraging the selfless and life-affirming work of these centers, some governments want to force them to provide free advertising for the violent act of abortion, in direct violation of their pro-life convictions and the First Amendment. The United States Supreme Court cannot let this happen. A ruling is expected by this summer. What is the ruling expected to be, and what were the arguments presented inside the Supreme Court? To delve into this, we turn to our next discussion. Carrie Severino is Chief Counsel and Policy Director of the Judicial Crisis Network. Amy Howe is co-founder of SCOTUSBlog, a blog devoted to coverage of the Supreme Court of the United States. Thank you both for being here.
Thank you.
Thank you. So first of all, Amy, was this a case about abortion, or is this a case about free speech?
This is a case about the First Amendment. What it boils down to is, can the government make someone say something that they don't want to say, that they believe is morally repugnant? But it happens in the context of these pregnancy centers that are strongly opposed to abortion, and so it really becomes a highly charged case.
Carrie, can you break down and summarize what was NIFLA arguing, the pro-life pregnancy centers? What were their arguments in the high court?
Well, of course, if you're forced to speak against your will, that isn't true free speech. So anytime there's compelled speech, and the court's considering this in several contexts this term, that implicates the First Amendment. But there's a real concern about this law in particular because it's not simply compelling speech against their conscience, but it's also appears to be what they called gerrymandered. It looks like this law is only targeted at the pro-life centers. So this isn't something that says everyone addressing abortion on both sides of the issue has to provide certain information. This is one step farther, where they're saying only the crisis pregnancy centers are required to advertise for abortion, and the abortion clinics are off scot-free.
Initial reports and analysis are making it seem that justices were more sympathetic to the pro-life pregnancy centers. Would that be your take?
I think that's right. I mean, the Supreme Court, one thing you have to remember is when you're talking about the First Amendment, the Supreme Court is very protective of freedom of speech, no matter who's speaking, and even when it's speech that the justices themselves may find objectionable. So they've ruled in favor of the makers of violent video games, people who make dog fighting videos, people who have lied about having won military honors because they believe very strongly in the First Amendment. And so you had a justice like Samuel Alito, who we might expect to be sympathetic to the centers, saying that, yes, you have this law, but it carves out all of these crazy, what he called crazy exemptions, and so it only winds up targeting the pregnancy centers. But Justice Elena Kagan was another justice who was very concerned that this might be unfairly targeting the centers.
Carrie, do you agree?
I agree. The Roberts Court has been, across the board, very protective of First Amendment rights. So I think any time, again, from all sorts of perspectives, that you're on First Amendment grounds, you're on very strong grounds before the court, because they want to make sure that free speech is robust.
I was reading through the transcript. I myself was not there, and there was this exchange about a Choose Life billboard. What was that about?
Yeah, so one of the triggers on the law is that you are providing counseling about abortions, and so Justice Alito was suggesting that it could even be triggered by having a Choose Life billboard and saying, well, they could say, well, look, you're providing these counseling services. Now you may have to have trigger all of the requirements in multiple languages, saying, for example, we are not a licensed medical provider is one of the requirements. So this is one of the problems with the just overbreadth of this law that seems to be trying to sweep in all sorts of pro-life speech.
Amy, Carrie hit on it a bit in one of her responses earlier, but the justices did bring up the issue of gerrymandering, which is a term we usually talk about when it comes to elections. What was that point about exactly?
It's been on their minds a lot. The day before, they had ruled in a case involving partisan gerrymandering in Pennsylvania, and the next week they'll hear a case about partisan gerrymandering, drawing districts to favor one party or the other. So it was something that's been on their minds, but here they meant that they had this law that California had passed that on its face appeared neutral, but as Justice Alito said, carved out so many exemptions that when you got down to who actually had to follow these rules, you really only had the pregnancy centers.
This might be an impossible question to ask, but if you had to predict how you think the justices will rule, how they'll sway, what would you say?
I think after yesterday's arguments, I'm feeling very confident that this law has so many issues that it's not just even a 5-4 situation which you often would expect in a high-profile case like this. It seemed like there were other justices, as Amy mentioned, Justice Kagan as well, seemed concerned that this was a law that was unfairly targeting one group. And so I do think that California may have to reconsider its policies after the Supreme Court rules, but we won't know till June.
I think that's right. I don't think it's going to be one of these 5-4 nail biters. I think what will be interesting is exactly what the majority opinion says and whether some of the more liberal justices like Justice Kagan try to get the court to write an opinion that maybe leaves open the possibility that other rules that apply more broadly might pass constitutional muster somewhere down the line.
Amy Howe, Carrie, Severino, thank you both for being here for this discussion.
Thanks for having us.
Thank you.